if you're an ESD commissioner, you had to take the Open Meetings Act basic training, and you had to take the Public Information Act basic training. You had to take 1 hour of both of those within 60 days of your taking office. That may be the last you ever did any open meetings or public information training. So this could be, you may have some questions, but what happened is we had this legislative session. You may have heard a little bit about it in this past spring. And the legislature, as they're wont to do, made some changes and updates to the Open Meetings Act and the Public Information Act. And we're going to talk about some of those changes and just have a general sort of open dialogue about what's going on in open meetings, public information, the general category of open government, I guess you would say. Tonight we have two representatives from the Office of the Attorney General to discuss the changes to those acts. Jenny Holscher serves as the Division Chief of the Opinion Committee of the Office of the Attorney General. That's a long title. Prior to joining the agency, Ms. Holscher was an attorney in the appellate and litigation sections of Brown McCarroll LLP in Austin. She also served as a briefing attorney to the Supreme Court of Texas. Ms. Holscher received her JD from the University of Texas School of Law and her undergraduate degree from Baylor University. We also have Justin Gordon here with us. He's the Chief of the Open Records Division of the Office of the Attorney General. Previously, he was an Assistant General Counsel in the General Counsel Division of the Office of the Governor. Another long title. Before joining the Governor's Office in 2011, Justin served as a Senior Attorney and a Drafting Attorney in the Open Records Division of the Office of the Attorney General. Justin earned a BA from the University of Texas at Austin in 2002 and a JD from Baylor Law School in 2005. So you guys kind of switched up. One of you, Baylor undergrad and UT undergrad, and then you went to the opposite law school. So very cool. We're very thankful to our folks from the AG's office to be here. This is the part where I give you the disclaimer that none of this is supposed to be an official opinion from the AG's office. You're specific. I know y'all like to get facts-based, your questions in with your fact-based specific to your ESD, and that's fine, but we can't give you any specific actual legal advice here. I think you know that. Any actual things going on in your ESD, you should probably check with your own legal counsel before pursuing. I think, did that cover it enough? Are we covered on the on that kind of stuff? So good. Let's go ahead. We're not going to have really a PowerPoint today. What we did is kind of different. Basically, if you look underneath your viewing screen, you should see a list of bills that we're going to talk about. And we're going to do the open meetings first, and we're going to do the Public Information Act first. No offense, Justin. It's just we're going alphabetically, I guess. We're going to talk about some of those bills. Again, I'm inviting you to get your questions in if you have them. And again, general open meetings or public information questions are okay with all the caveats I discussed earlier. And we're just going to go through the changes, that the major bills that affected this past session. So Jenny's our open meetings person tonight, and we're going to talk about first, and I knew this one was coming up. I knew we were going to have to talk about it. The public comment requirement. The legislature saw fit that they really wanted to let the public have their involvement in your meetings, your ESD meetings. So they made a new public comment requirement. It was House Bill 2840. There's been a lot of rumors going around about what this bill actually requires. Is the public going to get to run the meeting now, or they get to talk about do they get to start actually voting on stuff? What's going on here? So Jenny, 2840, just real quickly, let's go through it.
Sure. Okay. So 2840. It's section 551.007 of the Government Code. It was a new provision, and it applies to all political subdivisions. So it doesn't apply to doesn't apply to state agencies. It applies to all of the political subdivisions that are subject to the Open Meetings Act. So it requires a governmental body to allow each member of the public who desires to address the body regarding an item on the agenda for an open meeting of that body to address the body regarding that item either before or during the governmental body's consideration. So a lot of governmental bodies are having public comment, and they have been having public comment, so this might not be a change. But if you weren't having public comment before, which you weren't required to under the Act before, this now requires you to do so, and you have to have that public comment during your open meeting, and you have to do it either before or during your governmental body's consideration of the specific item.
So, okay, let's. This was written by a lawyer, probably, this bill.
Probably. I don't know who wrote this.
Okay, so let me see. So previously, they did not have to have a public comment section on their agenda.
That's right.
Okay.
It was optional.
A lot of you do. Many of you do. I know most of the leading ESD attorneys in the state suggest that you do just to keep your public happy. And I also know, before you say it, because you might be thinking it, that no one ever shows up to your meetings. In some cases, that's true, and I understand. You still have to have it, right?
Right.
So now you do have to have a public comment section on your agenda during your meeting, and so can it just be there? Do we think it's sort of ambiguous, kind of like.
So this takes effect September 1st. So we haven't seen any sort of interpretations of this yet about what it actually means. I think that, at a minimum, it means you have to have a public comment section at least at the beginning of your meeting before you discuss any of the items on your agenda. But there are certainly governmental bodies that have started having a public comment section at the beginning of every agenda item.
So, and that's one of the rumors we've heard is, okay, do you now have to say, okay, item 1 on the agenda, discuss paying the bill for the new bunker gear, and then you discuss it, or before you discuss it, do you have to open it up to public comment? Okay, we moved on, we've paid that bill, now agenda item 2. I don't know, I'm blanking here. New contract for the service provider. I'll go something big, but basic. Public comment on agenda item 2. Anybody choose to speak? No, hearing none, we move on.
Right.
That you're saying that some governmental bodies are doing that just to kind of double check and make themselves super safe, right?
They're following, the very literal reading of this new bill. And they're requiring members of the public to register in advance, and so they'll know how many people are going to speak on each item.
Okay.
I think that's a reasonable rule. This bill allows the governmental bodies to adopt reasonable rules to implement this new requirement. And so, we'll see what those new rules look like. But there are going to be entities that are going to require people to register in advance so that they know 10 people are going to speak on this given agenda item. 5 people are going to speak on this one. No one's going to speak on this one. They'll have some idea about how long that's going to take.
So can, and maybe you said this while I was looking for questions, but so can they limit the amount of time each person has to speak?
So they can. It specifically says that you can place a time limit, a reasonable time limit, on the amount of time that each person has to speak on each specific item. So, if someone wants to speak on more than one item, you need to let them do that, but you can limit the amount of time that they get to speak on each item.
Okay. Yeah, because this was our first question, which is a really great question. Is there a requirement in the code that determines how long a member of the public can speak to an agenda item? So there's nothing in the code that says only this long or it has to be this long, but it says reasonable.
Reasonable.
So you can't say, you have 10 seconds to talk about this issue.
Right.
Hurry up and get everything out that you can in 10 seconds, and then, okay, so you can't, because that's not really reasonable.
Right.
The main goal here is to let the public address the body, the governmental entity.
That's exactly right.
Many of you were already having this on your meeting. Sorry, I was looking at the wrong camera. Many of you already had this, and that's great. You're going to need to consult with your attorney or legal counsel, or maybe the Open Government Hotline, I don't know, about how to go about implementing this requirement. Remember, when we do our ESD 101s and we do our different trainings, ABCs of ESDs, I'd always say, the public had a right to attend your meeting, but they do not have to have a right to speak. That's changed, okay? So that's a big change.
Right.
They do have a right to speak. They have a right to address any agenda item they want.
That's right.
This does not affect executive session or closed session, does it?
No, I don't.
Because they can't be there.
Right. I think. Well, and this, if an item is on the agenda, I think they do have a right to address it. They certainly can't go into closed session.
Right.
So but if you have an item on your agenda that you're addressing in closed session, you probably want to provide an opportunity for them to comment on it to some extent in an open session to be safe.
Right, and your agendas, executive session. We can talk about that if somebody has a question out there, but we're not gonna delve right into that right now.
Right.
Okay, so that's the public comment requirement. Again, consult your attorney about how to implement it, but they get to talk to you now. Basically, they get to address your ESD board as the body. I know many of you are out there saying we would love for people to show up so they actually can get involved in the ESD and we can recruit new board commissioners and everything. Some of you say no, you don't want that because they show up when something's wrong. But either way, they now have a chance to comment on your meetings. So that's the important takeaway from House Bill 2840 if you're looking to read it, and we have a link on our site. Let's talk about Senate Bill 494. This came out of Harvey. Emergency meetings. Go ahead and give us the rundown.
And this is not a significant change. So there used to be a 2-hour notice requirement that you needed to give before you were going to conduct an emergency meeting. And this just narrowed that 2-hour requirement to 1-hour requirement. So now you just have to post notice for an hour. And then the legislature also gave some explanation as to what emergency is. They just clarified it does mean a hurricane, it does mean a flood, it might mean a transportation failure, it might mean an epidemic. It just gave some examples of what it meant. We used to get a lot of phone calls about whether something was or was not an emergency. So I think there was an effort to kind of clarify that. And that bill is also something that Justin's going to talk about because it also relates to the Public Information Act. But there was a little portion of it on the Open Meetings Act as well.
Okay, so it's basically the posting requirement from 2 hours to 1 hour, essentially. Right. It was 2 hours. Ken Campbell likes to say you do not have an emergency meeting. Just as a refresher, you have you have regular meetings, which is what you have to do every month. You have your special meetings, which are just the same as regular meetings. It's just in addition to your regular meetings. So posting requirements are always the same, 72 hours, all the good stuff that you have to do. And then your emergency meeting is really for an emergency, and it's a big deal.
Rare.
None of that was changed, really.
Right.
They just sort of fleshed it out a little bit more and dropped it to 1 hour because a lot of folks in Harvey were saying, we really could have used, we didn't want to, we were just sitting around for 2 hours waiting. Right. We could maybe do one. And aren't there requirements to alert the media?
There are, and there were requirements to alert the media before. Now it's clear that you have to alert the media within an hour as well. But not really a change.
Yeah, not huge substantive changes, but it's still there, so they didn't take that away.
Right.
Let's talk about SB 1640, criminal provision related to walking quorums. Walking quorums, you guys always have a lot of questions on walking quorums. So.
Yes. All right, so 1640 was actually a response to the Court of Criminal Appeals decision in February where it struck down the former provision that made it a criminal offense to conspire to circumvent the act by meeting in numbers less than a quorum. So that bill had been on the books for 2 or more decades, and it had been enforced by the courts. The Court of Criminal Appeals in February ruled that it was unconstitutional because it was vague and it wasn't clear what conduct was prohibited. And so this was the legislature's response to the court striking that down. Basically, this is, no, we really mean we want to prohibit you from having conversations outside of a meeting. And so this is a new way to sort of phrase the same law. And they're trying to prohibit governmental bodies from having a series of communications that occur outside of a meeting where a deliberation occurs among a quorum, and then that conversation doesn't happen before the public. So similar, but the language is different.
So there is a criminal. Well, let's just, as a refresher, talk about what is a walking quorum.
Okay.
Like a walking quorum is when they meet in numbers less than a quorum and actually do business.
And deliberate and have a
Right.
conversation. Maybe they decide something. The best example of it from the previous statute, which is no longer on the books, was where a city council met in the mayor's office the night before their city council meeting. And there was never a quorum there, but through the course of multiple meetings that didn't involve a quorum, they reached a consensus on the budget. And then the next day, they went into their open meeting and they voted on the budget. They had no conversation about it. And so, a lot of people that were affected by the budget decisions wondered why there wasn't that conversation, and they discovered later on that that meeting had actually happened the night before among this sort of daisy chain of meetings. And so that is basically what the legislature is trying to prohibit. We want these conversations in the open so that members of the public know how these decisions are being made.
Right, so it's essentially no back channeling, basically.
Exactly.
It's trying to get around that, and there's a criminal element now that is reinforced through this bill, basically.
Right.
Okay.
And so what it prohibits now is a series of communications that each occur outside of an authorized meeting. They concern an issue within the governmental body, and the members engaging in those communications don't ever constitute a quorum individually, but through the series, they constitute a quorum, and they deliberate about a subject outside of that meeting.
Okay. So this is different than just a simple case where you have three people hanging around in a restaurant
Right.
who happen to all be on your ESD board, and you start talking ESD business. That's just a straight violation of the Open Meetings Act, right? Because you didn't post. You have a quorum,
Right.
3 out of 5, and you've now got a meeting basically that you didn't post, right?
Right.
Important to understand there is an exception to the act for conferences, trainings, workshops, so you don't have to worry about this when you're at the safety conference in February. So I want to make sure that's out there.
Right.
Okay. Let's go on. So we have some open meetings. Those are the big 3 open meetings bills that we're going to talk about tonight that we wanted to make sure and catch you up on. If you have any questions, be sure to get that to us. The numbers will probably be put up on the screen while we're discussing the PIA. So, Justin, let's turn to you and go with the Public Information Act. Now, there was a big omnibus bill. That's Senate Bill 944. Tell us a little bit about that, because omnibus means it had a lot of stuff in it.
Sure, it did. One thing to note before we jump into these bills, we're going to talk just about a handful of bills, but the Attorney General's office is going to put together and publish on our website a legislative update for members of the public and governmental bodies to use, and so that will be up and available on our website next week. So on September 1st, we're going to talk about a handful of bills tonight that have new forms. We're going to talk about a handful of these different bills. We're going to have resources about them on our website. So
Okay.
if your audience misses one of these points that we talk about on this omnibus bill, when there's 6 issues, well, they're going to be up on our website next week as well with some additional resources and links. So, Senate Bill 944, PIA omnibus bill. It was where a lot of different things went to be passed during the legislative session. A number of which are very important for your audience. So, the first is a temporary custodian process, and so temporary custodian is the buzzword that they use during the legislative session to refer to members of governmental bodies who were maintaining records outside of the official records maintenance of the governmental body. So, for example, a board member maintains emails on their own email account, or they write notes and they take those notes and they maintain those notes personally on a private in their private papers. So, the legislature created a temporary custodian process where it requires the governmental body to go and get those records from the temporary custodian who's maintaining them in order to get them and release them to the requester. So, specific process, there are different deadlines, and there's a specific process requiring the governmental body to go and obtain those records. And it has some enforcement provisions with respect to confirming that there's no property interest in those records, and really confirming that, hey, the government body can come and get these even if they're maintained privately and independently by a current or former official.
So, and this was, I went to the appraisal district conference a couple weeks ago, basically to try to learn about Senate Bill 2, which is not what we're here to talk about tonight. But they had open government, and they had a speaker on this change, and the temporary custodian thing bewilders me. What kind of, so in their personal email, so if they have what could be a record, considered a record, that they send in their email, their personal email. Mm-hmm. So what can you? I know you can't speculate too much, but what is an example of that? Like. Sure.
So I think a very obvious example, and this arose from a court case, so it's pretty. I can give you a pretty clear example where you had it was either a city council person or a county commissioner who was just conducting everyday business, so just normal city or county business on their email. So they really, for lack of, just imagine they didn't have a official email at all. All of their work was done in their email. Well, then they received a request for it, and they said, well, that's my personal email. You, governmental body, don't have access to my email, and so I'm not going to give it to you.
And so now the governmental body has a responsibility to get access to that person's personal email to obtain those records.
That's correct. They request it, and the temporary custodian is required to turn it over.
And this expands to, as you said, personal cell phones, right? Like text
Sure.
messages,
Mm-hmm.
possibly personal Facebook pages and social media. Would that be under the?
I think that if you're doing official business on them, it certainly could. So it really covers public information wherever it is. So a lot of this is a codification of our long-standing interpretation that this information doesn't matter where it is. If it relates to the transaction of official business, then the Public Information Act covers it. And it's meant to kind of catch up with technology where so many folks are doing business on personal devices, and access to those devices is not clear cut because they are owned not by the city, not by the county, or not by the district, but by the individual who's conducting the information. The second component of 944 is actually related to this, and what it does is it clarifies that the possession and maintenance requirements for information maintained on personal devices. So it specifies that if there is public information that's maintained on a personally owned device, then the owner of that device has to either maintain it on that device in accordance with their retention schedule, or forward it to the public information officer for the governmental body. So very clearly lays that out and kind of trying to catch up with that modern technology where folks are maintaining so much on what may be a personal device.
Right. So, and it gets scary when they hear that, my personal cell phone may be subject to the Open Records Act, right?
Sure.
And the Public Information Act. So there are protections in there for, making sure that personal information is redacted and stuff like that, right? And
so information that does not relate to the transaction of official business is not subject to the Public Information Act. So it's only the information that relates to the transaction of official business. Sometimes, practically speaking, that can be difficult to separate, especially if in the same email you're talking about personal, then you're talking about work. So we always suggest at our conference and on the hotline that to the extent you can, 2 devices or 2 accounts, and maintain the personal business separate from the work business, and then you do not have to worry about that.
Okay. Yeah. I mean, there's a lot of angst over this. I'm sure it's not as bad as people want to think it is, but it's one of those things that can get kind of scary when you start talking about personal Facebook pages being open records and stuff like that.
Sure.
What else?
Yeah. So I'll kind of move through these relatively quickly. In fact, some of these 6 components are completely inapplicable to your audience. Things like, peer review, confidentiality, and a couple of these other sections. One of them, though, that is a big change and that I think that districts definitely need to be aware of is the new process for receiving Public Information Act requests. So, under the Public Information Act, requesters right now, as we're speaking, before September 1st, are allowed to submit requests by hand delivery, the mail, email, and fax. So pursuant to SB 944 and the changes in that bill, governmental bodies are going to be able to designate a specific mailing address and a specific email address where they receive requests, and all requests have to go to one of those two addresses and be directed to the public information officer, or they can be hand delivered. So those are the three options. Governmental bodies are no longer going to be required to accept requests by fax. And it also clears up the question of, well, can I email it to or mail it to anyone? It makes very clear that no, it has to be mailed or emailed to that designated person.
This kind of begets that question. Are public entities required, I would suppose, to designate that place of receiving public information?
So they're not required. The
Okay.
statute talks about designating it. If they don't, then it falls back on the
Okay, so
default,
it's
which
back
is the
in the
public
old days,
information,
okay.
public information officer or the chief administrative officer.
Okay.
So there's a reason to designate, because then you know they're all going to go to the same
One
place,
place, yeah.
one place.
Cool.
And it also allows them to create and accept them by any other way that they want to. They just have to specifically authorize it.
Okay.
So they can get it by fax if they still want to get it by fax. We have a lot of folks who are using these online portals now, no problem. Social media, if folks want to do that, they could take them that way. I haven't seen anyone opt in on that yet, but we've had that question come up. So anything going into the future, governmental bodies can opt in and do it that way.
So the governmental body can opt in
Correct.
to using a specific
Technology
Can they do
or-
multiple?
Sure,
Yeah,
they can do
so-
whatever they want.
But they don't. But there are only a few ways in the statute that it says they have to.
Have to do it by mail, email, or hand delivery.
Mail, email, or hand deliver. Okay.
That's right.
Good refresher there.
Yep.
Okay. Cool.
And then we're also last kind of our own pitch, and I should have talked about it when I talked about the website. But we're SB 944 also requires us to promulgate a new Public Information Act request form. So for your audience, if they don't have a form currently, or maybe they have an old form that they haven't reviewed, we're going to be promulgating a new form. Its use is completely optional. It'll be up on our website on September 1st, and government-wise can go there, download that form, and know that the form that they're using has been reviewed, that it covers all of the bases. It also allows requesters to opt out of receiving confidential information in order to streamline the process for requesters and governmental bodies. So we're hopeful that that request form will be a tool that governmental bodies and requesters can use going forward. But that's part of SB 944 too.
So this is a form for requesters to actually submit to the governmental body.
Correct. It's a Public Information Act request form,
Okay.
and they just fill it out, send it to the governmental body, and that would be their request. Governmental bodies can also put it on their website or wherever they want and let requesters use it.
Because it meets the statute reviewed by
Correct.
your office. Let's make it clear, though, they don't have to use that, right, to request public information. So
Correct. That is
I don't-
optional.
I just don't want anybody thinking, well, this didn't come in the AG's prescribed form, so I
Right.
don't have to respond to this. You still have to.
That's a
yeah.
great point.
Yeah, I
Yes,
just want to
you-
make sure that we know that. Like, no get out of jail on that one, but okay.
Right. That's a great point. They can use the form, but they are not required to do it. And governmental bodies aren't required to use it or put it up on their website either. It's completely optional for everybody.
I do want to, real quick, since we're talking about the website, texasattorneygeneral.gov, right?
That's right.
Right. There's no .state, nothing of that. texasattorneygeneral.gov, great website. When you get on the main page, it has like 4 different
right.
things, and on I think the far side is open government.
That's great.
That's the portal. Tons of good stuff there. If you ever have a question, that's the place to go. Tons of resources. It's really great. I'll hit it again before we close tonight. But texasattorneygeneral.gov, if you want to check it out right now, you can while you're. But also watch the webcast. Keep watching. All
There
right,
you go.
Let's go forward.
Sure. So the next bill that I was going to talk about that is, and you've already talked about contracting a couple times in your example. So SB 943 is a major change to the way that access to contracting information in the state of Texas works. Really completely overhauls the existing law, has a number of important elements. So if you are a governmental body who's doing any type of contracting, this new bill is going to change a lot of things for you. The first is it confirms that the competition and bidding exception, which we refer to, it's in 552.104, it confirms that that section only applies to governmental bodies. So third parties are no longer allowed to raise it. That's a very broad exception, and in the context of third parties, really resulted in withholding a lot of contracting information that the legislature wanted to be going out. So confirm that old exception, that's just for governmental bodies to raise. Then what they did is they created a subset of information that they refer to as contracting information in the statute, and they specify that that information falls under contracting. It's things like pricing, dates, parties, signatories, deliverables. That information cannot be withheld under the typical exceptions in the Public Information Act. So can't be withheld under the new proprietary information exception, can't be withheld under some of the other exceptions. And it creates a laundry list of things that need to go out the door and that those exceptions will not apply to. From there, it creates a new exception for proprietary information. That's a broad exception. And it also updates the old trade secret exception to a new trade secret definition. We could spend 2 or 3 hours just talking about this bill and the new standards, but it is a significant change that folks, if government bodies are doing any type of contracting, they really need to look at that bill, have their contracting staff be familiar with it. It has specific requirements, so it's not just a bill that's going to happen to governmental bodies, it's a bill that governmental bodies need to go out and comply with. There are things that, there are requirements that the contracts have to include statements, certain statements that the contractors sign on to. And like the temporary custodian, there's a process by which governmental bodies have to go and get information from their contractors if they don't maintain it themselves. So there's a lot going on in that bill. Definitely something that that governmental bodies need to look at and be familiar with. The good news is that bill is not effective until January 1st of 2020 from the standpoint of implementation. They don't have to worry about this popping up next week. They've got until January 1st of 2020 to be prepared and be ready for it.
Okay, so this sounds like a complex one, and I want to make sure and get the headline. So SB 943, contracting and bidding information. This is basically creating new requirements about what information governmental entities can be requestable in a public information request, or that they just have to have for their records?
Can be released. It changes, the biggest changes, is it narrows what can be withheld from a requester and expands on the information that needs to be released. So it narrows the applicability of several exceptions, creates a laundry list of items that can't be withheld under those exceptions.
With regards to your contractors and your contracts, right?
Exactly.
So, and so that's an important thing, that if you are an ESD that has a bunch of contracts and does these kind of things and does bidding, you're going to want to have some legal counsel talk about SB 943 and make sure that you guys, like Justin said, there are some requirements that you're going to have to comply with in terms of being able to disclose that information that's no longer accepted from the Act, right? Is
Correct.
that fair? Okay.
A lot of government bodies may have gotten used to just a lot of their contracts being withheld if a third party raised an exception. Mm-hmm. That is not going to be the case anymore. There's going to be information in those contracts that has to be released.
Yeah, so the third party exception, objection exception for not disclosing contract information is
significantly narrow.
Significantly narrow. Not gone, but significantly
narrow.
Okay, fair enough.
That's right.
Good deal.
On a related note, if any of your audience are having parades or events, entertainment events or concerts, those contracts now are specifically open. So it doesn't seem like the type of thing that you guys would have, but just in case, if any of you guys are out there.
They do.
Yeah, or having those events, if you have a contract for a parade, concert, or other entertainment event, the competition and bidding exception does not apply to it. That contract is going to be have to be released, and that is in effect now.
Okay.
So any contract that was executed after the effective date of that statute, it's HB 81. You can go check out that bill. But any contract for an entertainment event like that, that's going to be now, you cannot withhold that under the competition and bidding exception.
Completely open under HB 81.
That's correct.
Okay, that's good to know, because some of you I know do host some parades and stuff. So I've heard of that happening. So that's good to know.
The next one is building on the bill that Jenny had already mentioned, which is SB 494. It touches on the Open Meetings Act, but it really impacts the Public Information Act. What it does is it defines catastrophe and specifies that if a governmental body, if their ability to comply with Public Information Act requests is impacted by a catastrophe, they can put their Public Information Act responsibilities on hold in order to focus on that catastrophe. It allows them, in order to do so, it requires them to file a form with our office, and that's a form that we're promulgating, and it'll be up on our website when this bill goes into effect.
Before the emergency, right? Before the catastrophe.
So once they're impacted, they would file this notice.
Okay.
And what the notice does is we take the notice and we put it online. They're also required to post a notice as they would an open meetings notice. And what the effect of the notice is that it stops public information requests in their tracks and means that new ones are tolled until the suspension period ends. The suspension period can last up to 7 days, and they can extend it one time for a total of 14 days.
Okay.
So that's for a governmental body who is impacted by a catastrophe.
And the catastrophe is defined in the language of the bill, right?
That's correct.
And that's Bill 494, right?
SB 494.
Okay, so a lot of you out there might be saying, "Well, I don't understand. Who's going to be doing public information requests during a catastrophe?" Well, those of you who went through Harvey already know the media is going to sometimes be asking for emergency plans. There's a lot of information that they're going to, when they descend on an event like that, something that big and newsworthy, they're going to maybe submit some public information requests. I think a lot of local agencies were inundated during Harvey with public information requests that they simply didn't have time to respond to because there was a hurricane and mass flooding going on. So bill is kind of giving you a little break on that, right? Giving you up to 2 weeks to put the pause button on your public information request, right? Assuming you got to file that form. So, if it hits, God forbid, you got to file that form to get to when the catastrophe hits to make sure that you're free from public information requests, right?
And I'm really glad the way that you said it, pause. So it does not cancel requests or get rid of requests. It puts them on pause. So when that notice is formed, all of the requests stop in their tracks where they are if they are pending. The new ones that come in, they get put on hold. But as soon as that suspension period ends, they pick right back up. The requester does not need to resubmit that request. It comes right back up, and those deadlines start going. So it doesn't wipe the slate clean of requests. It just puts them on pause so that the government body can focus on responding to the catastrophe.
No stop, no delete, no reset, just pause.
Pause.
And then you pick up when the exemption or the whatever.
The suspension period ends.
Suspension period.
That's the term in the statute. Yes, sir.
I'll find words eventually. Okay, so let's move on.
All right, we're keeping it going. So HB 2446, this one actually directly impacts you guys. So under HB 2446,
let me just jump in here. That was a bill that actually came from a Harris County ESD was instrumental. Hi, Gail. We were safety didn't have the lead role on that, but we supported 2446. It's a big bill, so and we're happy that you're here to talk about it. So.
Sure. So under existing law, state employees, governmental body employees, they're permitted to elect to make their personal information confidential. So home address, home telephone number, family member information, social security number, and emergency contact information. Those things they can elect to make confidential in the employment context. So if their employer maintains it, they can elect to make it confidential. What this bill does is it makes it automatic. So under 2446, a firefighter, volunteer firefighter, or EMS employee, their information is automatically confidential under this bill in the hands of their employer. So they do not need to make an election. It just is automatically confidential. So it changes the current law, which requires them to file a election to make that information confidential, which is the standard rule for governmental employees in Texas.
Really? So they don't have to let anybody know that they want to take advantage of the exception.
That's the way it works in the employment capacity, so
Okay.
for their employer. There's a second part of the bill
Okay.
that changes 1175, and that requires them to file an election for records that are maintained outside of the employment capacity, so outside of the employment context. So anyone who maintains records, home address, home telephone, family member information, the other categories that I listed, for a firefighter, volunteer firefighter, or EMS employee, those can be confidential if the officer elects to make them confidential.
Okay, so
And that's in any capacity, any context, wherever those records are.
okay, so I'm going to ask a question that's really specific to ESDs here. Let's say you're employed by the fire department, and that's your employer, but the ESDs can contract as independent entities. You know, the ESD is the government contractor as a 501c3 volunteer fire department or a fire department. So they're at an arm's length contract. They're going to have to elect with the ESD, right? It's not automatically confidential with the ESD since that's not technically their employer, right?
I don't know the answer to that question. I think that
I
you're...
put you on the spot there.
Yeah.
It's oddly specific, and it's a very ESD-specific fact scenario.
I think that you are correct. Definitely when folks start dealing with this, you can call the hotline. We can look at that. Or if in doubt, make the election because you can't, it doesn't hurt to make the election. One of the things for just kind of normal employees in the employment capacity, the election has to be made before the request comes in. But in the non-employment context now, that election can be made after the request comes in if it's in the non-employment capacity.
Okay.
And if it's in the employment capacity, they don't have to make the election at all, and now it's automatic.
Okay. So that's great to know. If your employer of the firefighter or the volunteer firefighter, I guess they're not technically employees, but I'm sure it addresses that, like they're just of a volunteer
Yes.
organization.
Yes, I'm using employee
Right,
in the
right.
shorthand,
Gotcha.
but yeah, they'd be volunteers there too.
An EMS person, EMS provider, they're exempt automatically with their employer. Their information is automatically confidential. They don't have to make the election. Outside, again, I was at that appraisal district conference, and so like if your information is on file at the appraisal district, obviously that's not your employer. You don't work for the appraisal district. But as a firefighter, can you make that election to have your stuff confidential in their records, their governmental records?
So I don't know. When we're taking questions, I can look that up and look at the
Okay.
bill. When we review the bill, we focus on the Public Information Act. There are a number of entities or types of individuals who are allowed to also make that election with the tax code because, interestingly, these provisions that I'm referring to, they specifically exempt tax code information
Okay.
from them. But a lot of them include a second provision that allows the official to make an election with the tax office in order to make that information confidential. I can look at the bill while we're kind of talking to see if it
I
covers
shouldn't put
that.
you on the spot like that. I'm being a bad host. I shouldn't.
Sure,
I shouldn't
no.
sit here and come up with. It's their job to put you on the spot with fact-specific questions, and here I am just throwing them at you. Going,
That's right.
Hey, what
No,
about this?
it's a good question, and it should be pretty straightforward to answer.
Okay, so on 2446, I did get a question about that is specifically just quick. What do you have the effective date on that?
Yes, it is effective now.
It is effective now.
That's right.
Immediately. So,
Yes.
So not even September 1st. It's effective now.
Right. The second part of that bill, which also directly impacts your audience, is it makes firefighter, volunteer firefighter, and EMS work schedules. It makes them specifically confidential.
Oh.
So it's a big deal in the PIA. We have a brand new baby exception that we just got. So section 552.159, and that's a new exception that specifically makes those work schedules confidential.
So firefighter, volunteer firefighter, and EMS personnel work schedules are now confidential under the same sort of rubric of automatically with
It would be like a driver's license number,
Okay.
or
Just
it's confidential.
another piece of confidential information.
If you want to withhold
That's
it, you need to
interesting.
send it to our office and let us look at it. But yes,
Excellent.
It's a straightaway confidentiality.
I'm going to totally pretend like I knew that the whole time.
There you go.
So okay, and it's in effect now. What else you got for me on the PIA?
The only one I was going to mention really quickly, I know we're kind of running low on time, is really this is kind of a big picture bill because we had talked before the show started that some of your folks are now have body cameras and are using body cameras on the job. They passed a new update to the law enforcement body camera that applies to police officers, and it allows governmental bodies to show the body camera footage to people who are depicted on it without waiving the ability to withhold it from other folks who request it in the context of a law enforcement investigation. So a family member or an individual is involved in a police incident, they can review the body-worn camera footage, but the police department could still withhold it from the general public if it relates to a pending law enforcement matter or something like that. That applies to law enforcement officials and police officers. I just thought it was something that your audience might find interesting because I think that's the direction that we're heading with a lot of these things, where the legislature knows, hey, folks want to be able to see some of these things, but there's sometimes a bigger picture that also has to be contemplated. So they narrowly allow some folks to look at it in order to take care of that interest, while at the same time leaving the overarching interest there. And that's possible. There's not a specific statute for first responder body-worn camera, but that's something that could be on the horizon, and something this bill is something to think about as you're moving forward in that way.
So House Bill 4236 allows, I'm just trying to think it through. There's a body camera on a police officer, an individual's involved, they want to see themselves on it, they can request the footage, and the police cannot withhold it from them?
The police department is allowed to let them look at it. So they're not required. They have the option to allow an individual who's depicted on the video to view it without losing their ability to withhold it from someone else.
Okay. That is a good one to bring up. I know we had our session at the conference about body camera use in EMS now. A lot of EMS agencies and first responder agencies in general are going to body cameras. Those that can utilize those because you're interacting with the public. Stuff happens out there. We all know it. So we are seeing some ESDs turn to body camera use, and it's something to understand that the legislature is going to get involved with how that information is controlled, because it is essentially public information. You're interacting with a public official. So that's good to know, and that's something to be on the watch for. Excellent. So is that pretty much completes your list?
That's it, yes.
Yeah, excellent. So that's great, and we actually have a little bit of time for questions, and then we can get everybody out of here. Okay, let's start with this question. Does the board have to designate a public information officer even if no member changed from one year to the next?
So typically a government body is going to have a public information officer, and once that designation is made, they do not have to redesignate that person. What she might be referring to is that when new board members come on, they're required to take the training that you talked about at the beginning, and they are allowed to designate a person to take that training instead of themselves having to take it. Those are kind of two distinct issues. But if the public information officer doesn't change, they do not need to redesignate or identify that person. Okay. So you don't have to, if your board member, if the person leaves though, you probably have to redesignate a new one or designate a new person. Yeah, and if a new board member comes on, they still have to take the training, or someone else who they designate has to take the training for them. Very good. Or have taken it. But you should all take the training anyway, because it's important stuff to know. Okay, so right now our board only consists of 3 people because the county has not replaced 2 of our members. One resigned in January, one moved out of town in June. So they're down 5 spaces, they're down to 3. What constitutes a quorum for us now? This is a great question that I get all the time, and now I have an Assistant Attorney General to answer the question.
It's true, and unfortunately 3 is the quorum. Your quorum doesn't change because you have vacancies. And so, those positions need to be filled so that you can have more people, and because at this point you can't take action unless all your people are there, present at a meeting, and your quorum is still 3.
I thought that was the right answer.
Yeah.
I knew it, but I wanted to make sure. So yeah, 3 people, there's your quorum. If somebody's sick, your ESD can't conduct business, basically. Can't hold a meeting.
Right. But on the flip side, 2 of you is not a quorum.
Right.
And so, to the extent that you're concerned about walking quorum issues, 2 people don't constitute a quorum there.
Right. On SB 943, does this apply to current contracts as well, even if they were done before the effective date of Jan 2020? So current contracts.
No. So SB 943 has a specific provision in it that specifies that SB 943 is not going to affect contracts right now until it goes into effect, but it does not have a limitation on the contracts that it applies to. So, of course, we haven't seen it, we haven't interpreted it yet, but it does not appear to be limited to contracts that were signed before the effective date of the contract. If they want to see a difference, they can look at HB 81, because HB 81 actually does have a section in the enabling language that says that HB 81 only applies to contracts that were executed after the effective date of the statute. That 943 does not have that type of language. It only applies to requests that are received after the effective date of the statute, but it doesn't reference the applicability to contracts.
So it's possible that even contracts that you're under right now could be subject to 943?
Yes.
Okay, so that's important to know, because you may have a contract that you executed 2 years ago that you might have to, and there's nothing in the bill that deals with the applicability. So
right.
The HB 81, remember, was the parades and entertainment options one, and that only applies to parades that you have after Jan 2020, I guess, right? Or contracts that you execute.
For parades, I forget the effective date of the bill. It's sometime in May.
Right.
Is when that bill was actually executed.
So it may be effective already.
Yes, it is effective immediately, but only for contracts that were signed after the effective date of the statute. So you would have had to have signed the contract and then gotten a request for it, and then that contract would be out after that May date.
Right, whatever the effective date of HB 81 was.
Yes.
Right? Okay. We'll do one last one since they got it in just under the wire while it was going to close. Public info officer designation. Do you have to specify the individual, or can you specify a position, e.g. secretary of the board, say, so that when an individual leaves, you don't have to make the designation again? Of course, ensure incoming member is trained and all those things. So you make the president, you just say, the president is our PIO, whoever that may be in perpetuity.
Sure. I've never seen that. That sounds like that would line up to me. I suggest that person give us a call on the hotline, and we can take a look to see if that question has come up in the past. But if they're designating a particular position, I think that would be very similar to designating the person. You're really just designating the person who holds that position as your public information officer. And depending on how they do that, if they have that as a bylaw or as an ordinance, that seems to make sense to me. But call the hotline. We can give it a close look for you. But that seems to make sense to me.
There is one situation that could get them in trouble if you make it your secretary of the board and the secretary resigns or gets off the board, and then all of a sudden you don't have a PIO designated until somebody you can at least elect a new one. So that is one issue that I'm sure this person has thought through. But it's an interesting way to think about it for sure. Okay, I think we're pretty much. Okay, so I got that question. So we're good. Thank you guys so much. I want to hit the hotline or the website and texasattorneygeneral.gov. Am I saying that correctly?
That's right.
texasattorneygeneral.gov. Fantastic website. There's a lot of stuff, obviously, because the AG does a lot of stuff, but there's a specific on the front page. You just click on Open Government, and there you find all the open government information that you could ever want to know. Maybe, I hope, more than that, probably.